And welcome to How to Fairly and Legally Evaluate Applicants' Criminal History Information. I'm Mike Coffey, President of Imperative Information Group. This webinar is the latest in our series of webinars that are part of our Second Chance Employers Toolkit. We're putting all this information together both on the webinar side, but also blog articles and other things to help employers do a better job, a more effective job of fairly considering individuals with some sort of criminal history in a way that's fair to those individuals, but also protects the company. And a big part of that, and this is probably the most crucial webinar of the series, is how do we, as employers, evaluate what's relevant to a job, what's not, what should cause us concern, and what shouldn't as far as criminal history. So we're going to spend a lot of time on that today. This webinar is approved for recertification credit through HRCI and SHRM. So if you're watching this live on Facebook, you're not going to get that credit though. So you need to go to imperativeinfo.com/webinars and register and watch either the recording or watch the live presentation through that so that you can get recertification credit. And what will happen is after the webinar, we'll send you an email with a link to take a quick survey to tell me how I did in this, and then once you give me that feedback, you'll get the HRCI and SHRM information emailed to you. And even if you don't need the recert credit, when you get the email, if you'll give me the feedback, I would really appreciate it. We're always looking for ways we can improve what we're doing. With that all said, we will get rolling here. So first, let's do this poll. I'm going to launch it. So I really want to know about your policy regarding the use of criminal history. So some of you probably don't have any policy saying, and I'm not really talking about background checks, I'm talking about your policy related to actual use of criminal history, how you consider it. Do you have a policy that says we'll review it on a case-by-case basis, or we'll do it in this case or this way? Whatever your policies are, tell me about that real quick, and we'll leave this open for another second or so. Okay, I'm going to go ahead and still see a couple of responses popping in. I'm going to close it in 5, 4, 3, 2, 1. Let me share this. So you see that about a quarter of you don't have any policy at all covering how you use criminal history, which probably means that your hiring managers, if and when they find out about the criminal history, are making their own decisions, which may be good decisions or they may be bad decisions. And so that can be a challenge. About 40% of you said you do it informally. You review it on a case-by-case basis, which is what I hear from a lot of employers. And that's kind of the standard advice you hear out there. And we'll talk a little bit today about why that's probably not enough to really be helpful to employers to both make good decisions and protect themselves. About a quarter of you have a written policy about reviewing information on a case-by-case basis. And then less than 10% of you have some sort of policy that's more formalized than, I guess, a case-by-case basis. And that's what we're really going to promote today. It takes a little time, but it's worth the investment, I think, with the clients that we've helped implement that over the years. So I'm going to stop sharing those results. Close that. Great. So why do employers even care about criminal history? I think it's really important anytime we're talking about criminal history in the employment context that we remind ourselves why it matters. Putting the wrong person in the wrong job can affect, on a large scale, a company, because obviously you've got assets to protect, you've got employees to protect, you've got the public to consider in certain environments. And you've got the company's reputation to protect. But beyond that, some behavior, and we'll get a little deeper into this in a bit, but some behavior just kind of self-identify, helps an applicant self-identify to you that they're just a knucklehead. They just make bad decisions. They're not compliant, and they just aren't the kind of your best choice in some cases for employment. That's not to say everybody who's made some sort of critical error in judgment in the past, or had some sort of legal trouble, criminal legal troubles, is not an ideal applicant for you. But we'll see patterns sometimes that suggest that this person's not necessarily our best person. So at the same time, we don't want employers to be too conservative in their use in their evaluation, because we don't want them to miss out on hiring a fully qualified applicant, especially when unemployment's down around 4%. So that's my hope, is that as we go through this process, employers will be more open to hiring individuals with histories who were honest about them, obviously, during the application and interview process. But it is important that we all recognize there's a valid reason for us to know this information, just like you want to know the reason somebody was terminated from a previous employer, or maybe whether where they attended school, or when whether they graduated, or things like that. Or whether they're licensed, whether they have certifications. All of this is just are pieces of the applicant. But to protect the company, there are things we need to know to make sure that not only their competencies are right and their skills and education experience are right, but also that their behavior doesn't present a risk in the organization. So there are two ways that employers use criminal history. The first is just eliminating certain applicants. There are times where somebody's criminal history just flat makes them ineligible for certain kinds of jobs, right? In this case, on the left, you've got somebody about to fail a DWI, so roadside sobriety check, it looks like, and on the right you've got that's a bomb on the front end of that forklift. So this guy, assuming that his day doesn't get much better than that, may not be your best candidate to drive your forklift in your munitions factory, right? So those are, obviously, if that was a recent DWI and we're dealing with something like, munitions or anything, operating any kind of heavy equipment, you may, really think twice before you decide to put somebody into that role. But let's, think about a sexual assault. Somebody is convicted of sexual assault. Even 10 years ago, there are certain environments where that person is just not going to be a good fit. I probably wouldn't let them work with any vulnerable populations. I'd seriously think very carefully about it. Working with children or the elderly or the infirm, individuals who just, aren't able necessarily to defend or protect themselves. But for a lot of other positions, that sexual assault conviction may not be relevant at all. Somebody working in a warehouse or doing some sort of, physical trade where they don't come into contact with the public, maybe not. Maybe that's not such an issue there. But the problem is sometimes if you don't know this information, you wish you did later after something's gone wrong. So certainly there are times where somebody's past criminal behavior puts them in such a high risk that we really are going to eliminate them from consideration just based on that history, once we understand the full context of the information. But then there's also the situation where we use somebody's criminal history as understanding who they are relevant to who the other applicants in our applicant pool are, just like we look at their experience, where they've worked before, what kinds of roles and responsibilities they had, what their education is, things like that, and their behavior. I'm a big proponent of behavioral assessments. We don't sell them, but I swear by the predictive index. And if you need the predictive index and don't have it right now, give me a call. I can connect you to my trusted advisor in that area. But there's a whole bunch of things that we want to evaluate when we're looking at an applicant, and the criminal history is one part of it because it does tell us something. So here's how we may, and this is the way a lot of employers really end up using criminal history. It's less about excluding candidates and more about looking at applicant A and applicant B fairly. So applicant A here, we've got Dick. He's got 9 years experience, an MBA. We've got neutral job references, and he performed well during the interview, which is never a reason to hire somebody. Too many employers rely on their interview skills, and they think they've got this special insight into human character. that they can cull from the interview, and often it leads them astray. But he also has no criminal history. And then we got Tom, and Tom basically is a fully qualified candidate, similarly situated to Dick, except 4 years ago he had a theft by check, then an open container violation, and a failure to appear. So we've just got some knucklehead behavior, and really, actually, I haven't done this webinar in a year, and I should have updated these dates, because now we're in 2019 as we do this. So let's say that, let's move these dates forward a couple years so that they're more recent offenses. But we just see some, if this was all in the last couple years, we would say, well, Tom's kind of, none of this would necessarily eliminate Tom from most jobs in your organization, right? But Tom's just not taking care of business. He's not showing that he's very compliant. He doesn't make smart decisions, and he's constantly in trouble. Tom's going to take a lot more management than Dick is. And if everything else is the same, you've got two candidates. I, as an employer, and I am an employer, I'm going to look at Dick first, and I'm going to look more deeply into Dick before I proceed with Tom. Just like had Tom been terminated from a previous employer involuntarily, I would want to understand the context of that, but that's a bigger concern, as opposed to maybe Dick, who's had consistent employment for a long period of time. So those are the kind of issues that employers, where criminal history factors into employers' use or evaluation of candidates. And please ask questions throughout the webinar. I'll glance over at the question box on the other monitor over here, but if I don't, I'll make sure I answer them all at the end if any I missed. So when I'm talking about a bulletproof screening process, and this is really what we're talking about throughout this webinar series, I'm talking about more than just background checks. Your screening process really starts before you ever meet your candidate. Your job description should list what the criteria are for the job, including the ability to make decisions, to follow instructions, to comply with company policies, things like that. Those should be in your job descriptions, because a lot of what we're using when we're evaluating criminal history, or even when you're talking to previous employers about their performance, is this person compliant? Does this person, do what they're expected to do? Are they honest and forthright? Are they people who operate in a professional and courteous way with their coworkers, things like that? So that should all be in the job description, so that when you're evaluating all the information about their behavior and their character and those things, you can point back to the job description as saying, these are valid things that we've put in the job description. And then the criminal history policies and tools that you're using in your organization. And then again, we're putting these together before we ever meet an applicant. So we're not going to create circumstances unique to each and every applicant, because then that's where our bias falls in. So we want to create these policies and procedures before we ever meet the applicant. And then you've got your employment application, your criminal history inquiry process, and then the interview. And then at the very end of the process, the background check, which all the background check really should be, is a lie detector test. Did they tell us the truth throughout the rest of the process? And so somebody asked real quick here, Randy asked, should disqualifying criminal convictions be listed in the advertised job description? I would say no. We're having our next webinar, I believe, is about the criminal history inquiry, what to ask. But my argument is that you shouldn't, because I don't think you should ever have very few disqualifying criminal history items, because every applicant's criminal history is a little different. Just because somebody has even a high risk criminal conviction, there may be circumstances that surround that make you say, okay, well, given their experience and these other factors, we may consider them. So you don't want to discourage candidates. If anything, you say that that you will fairly evaluate every applicant based on the available criminal history information, and follow all the applicable laws. That's the other thing you're going to have. You're going to have laws on a state by state or even city by city level that limit what you can consider. And so, but I don't think you ever want to have anything that's a pure disqualifier, unless it's one of those exceptions where somebody's going to be working with vulnerable populations, or maybe you know there's a DWI. If you've had a DWI in the last 2 years, we're not going to hire you as a driver, something like that. But still there, I still wouldn't publicize that in your job description or in your job posting. I would leave that to be your evaluation tool, because you're also sending the message that, possibly sending the message that outside of those factors, criminal history is not relevant, and it may well be relevant. We'll talk about that in just a second. So this is what we consider a bulletproof screening process. So let's get into a little bit of the legal stuff around this. First, Title VII of the Civil Rights Act. It was signed in 1964 by President Johnson. It was in 1991. It was amended to incorporate the disparate impact language from some previous court ruling, and by the first President Bush. So Title VII prohibits discrimination based on race, color, sex, national origin, and religion. We've all heard this a million times. It also created the EEOC. So, and of course there are other laws, ADA, the Age Discrimination and Employment Act, GINA, things like that, that also prohibit certain kinds of employment. But in our context today, we're really talking about Title VII because of its impact on individuals based on race and color more than anything else, although possibly sex too, because men are prosecuted and convicted at a higher rate than women. So that's a possibility as well. I will say, under Title VII, under federal law, being a former criminal offender does not put you in a protected class. And a lot of employers get, because of some of the EEOC's actions over the last decade and a lot of the media coverage of some of these issues, a lot of employers get kind of liver quiver about how they're going to approach the use of criminal history. And I don't want you to be cavalier about it, but I want you to be confident. So we'll talk a little bit about some of the issues surrounding that. Obviously, Title VII created first the idea that of disparate treatment based on somebody's protected class. We can't in employment make decisions that exclude them from employment just because they happen to be a certain class. And in the context of what we're primarily talking about, we're talking about race and color, those kinds of issues. So we know what that is. We recognize it when we see it, and by and large, it has really been muted in the modern workforce. But there is the concept of disparate impact, which wasn't originally in the law, but in 1971, the Supreme Court ruled in a case called Griggs v. Duke Power that an employer, without necessarily even intending to, so without creating a, without intentionally treating one group differently than the rest, they could end up in a discriminatory position. In the Griggs v. Duke Power case, Duke Power required that anyone who's going to be a manager have a diploma in order to get into that kind of role. And this is not, this is the early 70s, and so individuals who were really raised in the 50s and 60s were coming into those roles, and Duke Power's Black employees had fewer opportunities to actually get that high school diploma. Mr. Griggs was an employee who wasn't going to be able to move into a supervisory role because he didn't have that diploma. And he sued, claiming that, first of all, this requirement doesn't make better managers just because you've got a high school diploma. And secondly, because you don't have a business reason for this, and it's impacting African-American employees at a higher rate than the rest of the population, this is discriminatory. And the Supreme Court agreed. And in fact, Mr. Griggs could even prove that there were managers before they had this policy at Duke Power who performed just as well as their peers who did have a high school diploma. And so the court recognized that if there's not a business necessity that you can defend, and it's creating a bigger impact on somebody in a protected class, then you can't really, you really need to re-examine that policy, or you're going to create illegal discrimination. So that was 71. So in 1975, Missouri Pacific Railroad, MOPAC, got sued. And in Green versus Missouri Pacific, what happened was Mr. Green applied for work at Missouri Pacific. He had a criminal history that he was basically during the 60s had been a war protester and had refused to register for the draft and some things like that, and actually served some, I think about 1.5 years of federal prison time. Well, Missouri, he applied, and obviously being a war protester and refusing to register for the draft probably doesn't directly affect most jobs at Missouri Pacific or at any employer. And so, but Missouri Pacific had a policy that said, other than minor traffic offenses, we don't hire anyone with a criminal history. So what does that mean? Well, regardless of what your past criminal behavior is, we're not going to evaluate the behavior. We're just going to say we're not going to hire you, period. That's what Missouri Pacific's policy was back then, 50 years ago. So Mr. Green sued saying, well, this is a disparate impact, right? Because African Americans in the United States are arrested, prosecuted, and convicted at a higher rate than the white population. So Missouri Pacific's policy doesn't necessarily, is creating a disparate impact on African American applicants, and it doesn't have a business necessity. His argument was, so the fact that he had, failed to register for the draft, or that somebody 25 years earlier had been convicted of shoplifting, doesn't affect whether they present a risk to the employer now, or they're competent to do this job now, or that their more recent behavior shows any signs that they would be a less than acceptable employee. And the court agreed with Mr. Green in that case, and the court suggested in their decision that employers should probably consider the nature and gravity of the offense. So what did they do? How serious was it? What was the underlying conduct? And how long ago was that? Was it 15 years ago, 20 years ago, 3 months ago? Makes a big difference, right? And what's the job that the person's being considered for? So if you've got a DWI 6 months ago, but all you're going to do in my organization is drive a desk, I probably don't care, right? If you're just going to be sitting at a desk all day, that DWI is not nearly as relevant by itself as it might be for somebody who's driving a motor vehicle or operating a forklift or operating some sort of dangerous or heavy equipment or just in a really safety sensitive position. So we need to look at what they did, how long ago it was, and what the job is, and put those things all together. Now the court, this is important, in this ruling, the court did not say employers must consider these things. The employer said these are things that employers may, that seem relevant, and an employer can consider these and other factors. And I always want to recommend that employers do consider other factors. And we'll talk about a few of those in just a bit. Any questions around, let's see here. How do you factor in the time since conviction factor in evaluation? Well, we'll talk a little bit more about that. I think Lance actually answered that question before I got to it. But we'll talk a little bit more about how we factor in what's relevant. That is something that happened 3 years ago relevant today, or 5 years or 10 years. Sometimes it may be, and other times it may not. We'll talk about that in a little bit more, Lance. So the bottom line is we want to look at the whole applicant, right? We want to, just as employers, I mean, you're not going to hire somebody for an engineering position just because they happen to graduate from a specific engineering school, right? We're going to look at what they studied, what else, what their experience looks like and all of that. We want to look at the whole applicant, not just their education, but likewise, we want to look at the whole applicant, not just their criminal history. So that means also we don't want to have policies or job postings that say things like clean background check required, because just like we talked about earlier, now we're telling every applicant who comes along who sees our job posting, oh, well, I've got that shoplifting from, when I was 19, 10 years ago, and they're requiring a clean background check, I'm not going to apply. Well, just from a recruiting purpose, that's a horrible policy, right? Because we don't want to lose good candidates because of something totally irrelevant to the job. You might as well be saying redheads need not apply. And so, those kind of policies are clearly going to make, dissuade good applicants from applying, but also, likely to create a disparate impact. No felonies allowed. This is the one that always gets pushed back when I'm consulting with employers. Well, we don't want to hire felons. Well, let's talk about that. What does it mean to be a felon? What does a felony mean? Well, all that really is about the level of the punishment for that offense. So it doesn't mean that offense is any more relevant to the job than a misdemeanor. In fact, there's times where a misdemeanor could be more relevant to the job than the felony. Like in Texas, your third DWI is a felony. So if I had got my third DWI 5 years ago, and like, I'm not gonna, you know, that's a felony, but does that mean that you're not gonna hire me for an office job where I don't drive or operate any equipment, and especially if my history is clean since then? Versus a misdemeanor assault 3 months ago, where maybe I'm dealing with the public, I'm going to be a lot more concerned with that assault and with somebody who's dealing with the public, even though it's a misdemeanor, than that felony. And so let's not exclude anybody strictly based on the criminal history, unless, you know, it's very, very narrow exceptions related to, you know, protecting vulnerable populations, things like that. And no convictions for theft or dishonesty. And it goes back to, that one's obvious too. I think when you think about it, somebody got convicted of shoplifting 20 years ago. Are we really going to eliminate them? Let's look at the context, understand what activity they engaged in, how long ago it was, and then we'll look at the job. So let's not do that. Let's not have these kind of policies. So the EOC in 2012 published a new guidance on employers' use of criminal history, and he talked about the green factors, you know, that we just talked about from the Green versus Missouri Pacific case. The green factors are the nature of the offense and the conduct, how long ago it happened, and the nature of the job and the responsibilities. So they took those in their guidance in 2012 and said employers should consider this, and then they added something that is not in the law or any court case really, called individualized assessment. And in the EEOC's own words in that document, individualized assessment generally means that an employer informs the individual that he may be excluded because of past criminal conduct and provides an opportunity to the individual to demonstrate that that exclusion does not properly apply to him. So in other words, why your policy shouldn't apply to him. So what does that look like? Well, they give a list of things that they think employers should consider. And let me walk through some of those real quick. The facts or circumstances surrounding the offense or conduct. Okay, so, you know, get the applicant side of the story. What really happened? And sometimes you see this. We'll see something that's a theft between $500 and $1,500. And maybe it is relevant what happened. Was it really just a failure to return rental equipment, or something like that? Or was it a true theft? How much? Was it 500 or 15? And who did they steal it from? What was the content, you know, the context of that relationship and that transaction? All those things may be relevant. Now I will tell you, just because the applicant tells you a story about what happened, doesn't mean that and on all of this, anything the applicant tells you, you accept it, always get it in writing, and then go try to verify it. Because I talk to a lot of applicants that, you know, we run thousands of background checks, and, you know, applicants call me from time to time and give me their side of the story rather than the employer. And often their story will change once, twice, 3 times through that conversation. So you always want to get their story in writing up front so that you've got something objective that you can verify against. But it makes sense to understand what was really going on there. If the applicant tells you something, if the behavior, and let me put it this way, if the behavior is of concern, and you've evaluated it in the way we'll talk about in a little bit, and the behaviors of concern, and the applicant sounds convincing, then always get your background screening partner to go pull court documents. Never accept the court documents from the applicant, because I promise we have seen doctored court documents from applicants where they look really legit, and then we go to the court and they're different than what's in the court's file. So always get your background screening partner to pull copies if you're going to accept the applicant's side of the story, so we can try to verify what was really going on. Sometimes it's, you know, the applicant's telling the truth, sometimes they're not. If you're going to make a well-informed hiring decision, you have to verify what they told you. But so you want to know that. They also suggest that let's look at the total number of offenses that the individual is convicted for. And that's really relevant there's some offenses, you've got, one sexual assault of a child. Nope, sorry, you're never going to work in my daycare center, period, ever. That's an exclusion. I don't care if there's just one offense or 50, it doesn't matter. But, it may be that there's a series of offenses, just like we talked about with Tom earlier. There could be a series of minor offenses that just tell you this guy is a knucklehead. He doesn't take care of business. He's not compliant. He doesn't follow rules, and he's going to take a lot of management time. He's not our best candidate. And so there's times where the number of offenses may be really relevant. Or maybe there's a series of offenses over 5 or 6 years that are more serious and would cause you concern about this, this person's ability to, decision-making ability and all of that. But if somebody just had one offense 10 years ago, or 2 or 3 offenses 10 or 15 years ago, and their history is all clear since then, and they've been out breathing free air, they haven't been in prison all this time, then maybe that number of offenses is relevant. Those 2 offenses, 3 offenses many years ago isn't really relevant. The EOC also points out that there are studies that suggest the older someone is when they serve their time for their last criminal offense, the older they are, the less likely they are to commit new offenses. Those are kind of loose studies, but a teenage offender has a 55.7% chance of being reconvicted within 3 years, according to a DOJ study, where a 45-year-old only has about a 30% chance of being reconvicted within 3 years. So your risk of a new offense with a teenage offender goes down from 55% down to about 30% with a 45-year-old. So there's some relevance there, but still, you're still, even there with a 45-year-old, you're talking about, a 30% chance that there's going to be a new offense for which they'll be reconvicted in 3 years. And now we're also, remember, talking about reconvictions, not criminal conduct, because there's no way to really measure that. We're just talking about, being caught and prosecuted and convicted of a new offense within the next 3 years. So, and as we all know, we probably have some family members who are kind of knuckleheads, and they're constantly getting in trouble or doing things that could get them in trouble. They just never fully get caught or whatever. So we have to remember that we're only talking about convictions in these studies. And it could be that just as they get older and wiser, they may not desist from that behavior. They simply don't get caught. And so, I'm always a lot more concerned with what their last behavior was and how long ago it was, and what they've done in that time to suggest that they've moved on with their lives. So what kind of work have they done post-conviction with employers and, where there's no criminal conduct? And so that makes sense. If somebody had an offense a number of years ago and they've been consistently employed with either this employer or another employer, and it's the same kind of work we're considering them for, then certainly that may be somewhat relevant in evaluating them. And then what's their total history? When we look at their entire employment history, what does that tell us about who they were? Was this one criminal offense an aberration where somebody just, made a really bad decision at some point in their lives versus the person who's just a common, knucklehead, and maybe their employment history also shows that they're a knucklehead, and they had this job, then they bounced over to this job, and they lost this one, then they had this criminal offense where they spent 6 months in jail, then they had this other thing. You see those patterns too. So let's just look at what they did. And this is what the EOC is suggesting that employers consider if an applicant tells you this. They're not saying you have to go ask all applicants about all of this information. And then what rehabilitation efforts have they made? What kind of education and training did they do? Things like that. And now now we really start to get into stuff that kind of, as an employer, as a career HR guy, these kind of things. Now there comes a point where they're asking employers to become social scientists, right? Where they want us to really dive into understanding what kind of rehabilitation efforts are effective and things like that. Well, nobody knows what's effective, clearly, because it's not working. You know, the recidivism rate is really high, and a lot of former offenders just end up back in jail. So if we really knew what was effective, then the prison systems and criminal justice systems would be taking care of it. So asking employers to be the people who determine what's effective and what's not doesn't seem quite fair to me. Certainly, if somebody has done something considerable to obtain new skills, maybe outside of jail, where they maybe had more volition about what they studied and what they pursued. If they've done vocational training or completed an associate's or bachelor's degree, things like that, those probably are more relevant than things that they took a Microsoft Word class in jail is probably a little less relevant. Doesn't mean that you're going to exclude them. It just means that they don't get as many gold stars in their evaluation for that. And then employment and character references. Certainly, if you can verify that they really did work for this employer and this employer says positive things about them, that makes sense. But character references, and I see a lot of employers, still list personal references on their employment application. And quite honestly, and we've got clients who are regulated by government entities, and they have to check personal or references, and so we check them for them. But that's just an intelligence test. Is this applicant smart enough to list 3 people who'll say nice things about them? That's what those really are. But every now and then, we'll be doing a personal reference, and somebody will say, we'll be on the phone with them and say, he listed me, and then they go throw him under the bus for the next half hour. But those may have some value. But the character references especially, I really don't care what their preacher says about them in the employment context, or what these people who think this person's a really great person. I wouldn't ever be concerned about that in the employment context. I'm a lot more concerned about what people who've actually worked with them and what former supervisors may say about them on the employment side. But on the personal reference side, character references, I'm not sure I'm nearly as impressed. And then whether the individual can be bonded under these different bonding programs. These are basically insurance programs for employers that say, okay, this person has a conviction for X. If you hire them and they basically commit the same kind of offense while working for you as an employer, and it causes you a loss, we will, on a limited basis, insure you from that loss. Okay, that's nice, and if you're a second chance employer, which you all are, everybody's hiring people with some sort of criminal history all the time. But if you're if it's a more serious offense and there's a program out there, go ahead and get that insurance. But that is never a reason to tip the scales in favor of an applicant because, well, if he does this exact thing. Because one thing we see from the thousands and thousands of criminal background checks we run is very few criminal offenders commit the same kind of offense repeatedly. I mean, certainly some, there are histories like with sex offenders and things like that where it's a real proclivity, but yeah, we see people that have a DWI here, a theft here, an assault here. There's not a pattern. And so knowing that I'm insured in case that person does something, well, the horse is already out of the barn by the time I'm collecting that insurance, and that insurance is not going to protect proactively my employees, the public, our assets, our reputation. So that's nice to have, but I'm going to argue that that's not something that should really influence the hiring decision. So if we're going to ask for this individualized assessment information, where do we do it? Do you really want to have that conversation with every applicant? Verbally, you're still going to want to get it in writing. Well, what we recommend is whenever it is in your process that you pose the criminal history inquiry to your applicant, and this is ours, and I think our next webinar is about what we really recommend around a criminal history question. We suggest at the same time you ask the criminal history question in writing that you also give them a chance to provide any of this individualized assessment information. So basically, If you believe that the information you provided about your criminal history above doesn't tell the whole story, there's additional information we should understand, then please provide it here. And I can promise you that I see tons of these documents have been filled out by applicants for our employers, and even when the applicants disclose their criminal history, very rarely do they provide this additional information. But when they do, I always recommend the employers, let's look at it and let's see if this employee's if applicant's criminal history is of concern to you. Let's dig deeper and see if their side of the story checks out, and maybe that'll affect how you feel about moving forward with a specific applicant. And then the EEOC does say in their guidance that if an applicant doesn't provide any individualized assessment information, then the employer can go ahead and make the decision without it. You don't have to pursue the applicant to get that information. They also recommend that employers not ask about criminal history until after they've either interviewed or made an offer to the applicant. And now there are some states and cities around the country that prohibit employers from doing that already. This is gospel according to coffee stuff, but my opinion is no, you want that information right up front, just like you want their college education, their employment history, and everything else, because you want to look at the whole applicant. But there are some jurisdictions where you can't inquire about that. So let's say we did inquire about it. Now we want to figure out, is this information, well, let me look at your questions. Pam Bratton, hi Pam, said that the more time that's elapsed, the less relevant the offense, and generally that's true. I think we covered that, but there are some offenses that, I don't care how long ago it was, that, you know, if you embezzled from a previous employer, you're probably never going to be my CFO. You know, and I'm probably never giving you any accounting access. There's certain jobs that I'm just not, you know, and certainly sex offenses and things like that. Intoxicated manslaughter. You're never going to be a driver for me. Things like that. But certainly, the older the offense, where there's no other behavior subsequent to it, makes it less relevant. And we're about to get into that. So what we want to do is say for a specific offense within a certain time, what concerns, what levels of risk does it pose for a specific job? So if some offenses would be low risk, others would be medium risk, and some will be high risk. So if it's low risk by itself, it's got really no effect on that person's eligibility or fitness for this position. If it's medium risk, we've got some concern about it. It certainly not going to be necessarily exclusionary, but we're going to get additional information and dig a little deeper. But if it's high risk, it's a real significant concern, and we're going to want management review before we extend an offer. We're going to get a lot more information and look at the rest of our applicant pool and really look at all of this information in context before we move forward with this person. And we may make an offer that has certain controls built into the position, like additional drug screening or things like that. So we're going to be really cautious. So how do you get to position? What does that look like, and how do we do that? Well, we've got 3 tools that when I sit down with a client, and you'll get copies of all of this with the information later after the webinar. After the webinar, I'm going to send you the email with HRCI information, or the survey, and then HRCI information after you complete the survey, and you'll also have the ability to download the slides, my notes, and these tools. So the checklist, the matrix, and then the relevance matrix are the 3 tools. So let's jump into those real quick. And the first thing is let's look at the specific position and see what is the risk inherent in the job. So what kind of access do they have? They've got access to personally identifiable information. They've got access to vulnerable populations or computer networks at an administrator level, things like that. Easily removable assets, like they work in a warehouse that isn't very secured and they can walk stuff out to their car, things like that. What's their supervision level? What's the work environment like? Is this somebody who is an outside salesperson and may never see somebody from the office throughout the week, or somebody who's working in a call center where they're constantly supervised? That level of supervision makes a difference. Do they work, is their work environment the warehouse or the office, or is it a customer's workplace, or is it a customer's home? Those kind of issues have different risk factors, obviously. And then what are their job responsibilities? They handle cash, they operate a motor vehicle or dangerous equipment, they counsel individuals on a one-to-one alone basis, things like that. So there's a whole bunch of different those categories. And then there may be industry or regulation specific concerns for a specific company or job that you need to address as well. So we go through and identify what those are, and then we move those up here across the top of this risk review matrix. And so like this first one's personally identifiable information is one of the access issues that we had a minute ago. And so if we're hiring an IT manager, this first line, crimes against people, is not really relevant to personally identifiable information access, but we may say in our environment, the fact that somebody's had some sort of financial crimes, fraud, embezzlement, things like that, and they will have access to personally identifiable information, individuals' names, dates of birth, social security numbers, things like that. Yeah, there's an intersection there of some risk with that kind of access and this kind of access and this kind of behavior on a financial crimes. So you can see, so we check that. And so you can see that that's where what we're doing is we're looking at each of those identified risks for the job and looking at broad categories of offense and saying, how do those relate to each of these risk factors? And it's going to be different for every organization too. For instance, a lot of credit unions and banks do fairly limited background checks on their tellers because they've got such good cash controls in place. And so they feel really confident not doing a thorough background check. I disagree with that because the reality is the insider threat from somebody who understands how the organization works, even if it's hard for them to steal money covertly, doesn't stop them from engineering a bigger fraud or providing the information about how the organization works to somebody on the outside. And if I see a behavior in their history that shows dishonesty, I'm going to be really concerned about putting them in a position for where they've got those kind of responsibilities or access. So we take those and we identify each of these broad categories that may be relevant to the job, and then we take them over to the actual criminal offense relevance matrix. So what that would look like is, if we're looking at crimes against persons, and this is an IT manager in this example, and because they're a manager and they're going to be supervising employees, we're going to have, for especially any kind of assault, domestic violence, we've decided that we're going to call that high risk if it's in the last 7 years. In this example, and again, every organization is going to be their own arbiter of risk. What would work for your organization for a certain kind of job may not work in another organization. And there's no science out there where you can just plug these numbers in and say, here's what your risk is. So every organization's got to, for themselves, determine what their risk tolerance is around each of these things. I don't want you to be too conservative because I don't want you to not have access to fully qualified candidates. But at the same time, I want you to recognize this in our culture, in our environment, these are the risks, and we're going to rate them accordingly as high, medium, or low. So you see some, a lot of these crimes against persons, because the person, this individual is going to be supervising and managing employees, are going to be high and medium because they're in a supervisory role where they have the ability to coerce or threaten or, bring some harm on people. But over time, you see a lot of these go from high to medium to low. And I'm going to, be somebody with a manager with a manslaughter, who accidentally killed somebody or didn't premeditate a murder more than 7 years ago. We may even call that a low risk offense in some organizations. So let's talk real quickly about a couple other issues that are out there in your policies. First of all, what about dismissed cases? Now, those of you who are in California and a few other states or even a few cities out there need to look specifically to what's going on where you operate because the rules are different. But generally, like we're in Texas, pew pew, I can pretty much consider everything about somebody's history in Texas and make a decision. And dismissed cases are not necessarily off the books for an employer to consider. In fact, the EEOC even said with arrest, and you hear this all the time, an employer can't consider, it's illegal to consider arrest information. Well, that's not true. It's not even what, there's no law that says that except for a few state-by-state issues. But the EEOC's guidance in 2012 said that an employer should consider the underlying conduct and is it reasonable to believe they engaged in that conduct. And so there are times where you go pull police reports and you see a history of certain kinds of behavior, even if somebody doesn't have a conviction, it may still be relevant. But so dismissed cases are a great example of where somebody may have gotten a deferred adjudication, they serve probation, and the case is dismissed. Well, certainly it's relevant to the employer to, the person served probation, they accepted responsibility for the offense, they pled guilty or no contest. So it's relevant. It's fair for the employer to believe that, yeah, they engaged in this conduct. And so now my question as employer is not did they get convicted, but is it relevant to, is it reasonable to believe they engaged in that conduct, and is that conduct relevant to the job? So you hear this a lot with deferred adjudications. My lawyer said it wasn't going to be on my record. Well, that's a problem with your lawyer. But the reality is that it may, typically in most states, dismissed cases are going to show up on your background check, and they may, in some cases, be relevant to the job. Now, the classification, is it a misdemeanor or is it a felony? That's another question that comes up a lot. And again, I would argue that your employer should be concerned with the underlying conduct, not the severity of the punishment, which is all misdemeanor and felonies are really about. What was the conduct and what does it say about this person's fit for this job in our environment? And what can be a misdemeanor in one state can be a felony in another. For instance, statutory rape in Texas is a felony, but there are versions of statutory rape in Louisiana that are misdemeanors. And so, but if my concern is this is somebody who's working with vulnerable underage populations, I probably don't care if it's a misdemeanor or felony in Louisiana. What I'm concerned with is the underlying conduct. What did they really do? And what does that tell me about the risk they may pose to the organization? And then what about pending cases? Just because somebody is facing a criminal case does not mean they engaged in that conduct, but it doesn't mean that, but it doesn't mean an employer can't consider the fact that they are currently facing charges. And I believe just about, I can't think of a state right now off the top of my head that has a prohibition against considering an active case against someone. Because even if they're found guilty, certainly that would be something where the individuals, maybe you've invested training time and all these things in this person, and maybe 6 months in your organization before somebody's fully productive, and then you get them right up to that point, you make all this investment, and now they're not available for employment because of because they're in jail, or maybe the behavior, if they're found, if it's reasonable, if they're found guilty of it or make some sort of plea, maybe that conduct is relevant to the job. So I always advise employers to go to their criminal history matrix and look at the behavior or the risk that you've associated with that behavior. And if this pending case suggests it's high or medium risk, then maybe we want to look at other candidates before we bring on somebody who's actively facing a case that we'd be concerned about already. What about warrants for their arrest? The bottom line is if they're wanted, they're not wanted here, go take care of those warrants, even if it's a traffic ticket, because you want to hire people who take care of their business, right? And if they have warrants for traffic tickets or whatever else out there, even if the underlying conduct wouldn't eliminate them from employment, we want you to take care of all your criminal history, all your issues out there, any open cases before you come apply here. What we don't want is marshals showing up one day, or you out at lunch one day and getting pulled over for taking an illegal left turn, and next thing you know, you're not coming back to work because you had a warrant out of another state even for your arrest. So take care of those before you come to work for us. Then attempted offenses or conspiracy to commit an offense. Just because they're, we recommend that employers treat these the same as though they had conducted they engaged in the conduct. They were trying to engage in the conduct and they just weren't very good criminal. So, let's not give them a bonus in the employment decision because it was only attempted murder or attempted theft or conspiracy to commit fraud. And they weren't good enough to execute on it. That's not, it's the underlying conduct and their intent is what you really want to consider. But I see a lot of employers who will have a lot of clients call us and say, now, what do this is conspiracy to commit fraud, should I give them a pass on this? And no, it's whether they, whether they were able to get away with it or not isn't nearly as relevant as, again, the underlying conduct and what their intent was. And then what about repeat offenders? I mentioned it earlier, but you remember Otis from Mayberry. He was always in the local jail with Andy and Barney there. But the issue is, this is somebody who makes, consistently makes critical errors in judgment that gets them in trouble. So even if those offenses aren't relevant to the job, you see a pattern of them, suddenly, I think all of us require somebody to have a certain level of responsibility to work for us, a certain level of compliance, rule following, basic safety awareness, things like that. And you see a pattern of just bad decisions and being a knucklehead, then they're self-identifying to you just through that behavior. They're probably not your best candidate, and they're going to require a lot more management time than you probably want to give them. Now, you do want to pay attention that there are state and local laws, like I've mentioned, that regulate what you consider when you ask about criminal history and all those things. And we're rolling out an updated guide for employers around the country on what their states and local municipalities allow them to consider. Now, I'm down here in Texas, pew pew, so we have it easy. Unless you're in Austin, there really are no prohibitions on employers' consideration of criminal history here in Texas and in most states, to be honest. But there are places, California, New York, Washington, basically the coasts and a few other locations around the country have some limitations on what you can do. So my bottom line is, let's review the whole applicant. Let's look at the experience, education, whatever, suggests that they're qualified and competent to do the job. But then also, I always weight a lot more towards their behavior, their aptitude, and their cognitive ability, because for most of our jobs, we can train people to do the job if they've got the basic behavior and aptitudes right. And their criminal history is relevant. It's one piece of the whole applicant, but it's not. Very few of us are just our criminal history, unless you're Ted Bundy or Charles Manson or something like that. Most of us, whatever, past offenses we've had, that's one part of who we are. It's not everything, but for certain positions, it can make us a less than ideal fit. And then interview performance, I always make that the smallest piece of my pie when I'm looking at applicants, because quite honestly, just because somebody is more charming doesn't mean they're going to be a better employee. And hiring managers often get fooled that way. So again, we'll send you the slides and links to the other tools we mentioned here. But also, I've got a whole book on the whole gospel of coordinating coffee and what I really think your entire employee selection process ought to look like and your screening process ought to look like. So feel free to go download that. It's on our website for free. I'll go look and see if I think I've answered most of the questions. The updated guide will come out probably in May, knock on glass. If I'm lucky and everything goes like I want, we'll have that out in May or early June. And I think that's all the questions. If there are any other questions, ask them real quick. Otherwise, we will roll up the webinar right on time, which is Karen Wells. Okay, Karen. Oh, are we protected if our offer letter states hiring contingent upon a clear background check? I wouldn't say a clear background check because somebody, let's say somebody's got a driving record, driving history, a driving history that's got a traffic ticket on it, or somebody's got a theft by check from 5 years ago. I wouldn't say a clear background check. If anything, I would say an acceptable background check. And you definitely, if you're issuing contingent offers, you want them in writing, and you want them to mention that you're going to conduct a background check, and that the background check will, the offer be contingent on management review and acceptance of the background check. Now, here's the real trick. Don't rely on the background check to identify somebody's criminal history, though. What you want is to ask the applicant in writing about their criminal history whenever you can legally do that. And so, and a lot of, some of the ban the box ordinances out there in states, they say you can't ask about criminal history until after you make an offer. That's fine. So at the same time you give them the contingent offer letter, you give them the criminal history inquiry as well, and tell them that they have to respond with an acceptance of the offer and the completed criminal history inquiry, within 72 hours or whatever your standard is, and that an offer acceptance will not be accepted by the employer unless it's also accompanied by that criminal history inquiry. Then, before you even run that background check, let's look at their criminal history and see what they disclosed to you, because it may be that they told you something right up front in their criminal in the criminal history inquiry that says, "Oh, this person is not our best candidate." And if that's the case, then you have that conversation with them, and you don't even have to waste money on the background check because you already know. And so then, ideally, all the background check is verification that they told you the truth. So you may not even, if you're in a place, in one of the jurisdictions that limits when you can ask about criminal history until after the offer, you probably want that built into your offer letter as well. And let's see if there's any questions. You can ask about the criminal history in most states and most cities in the country. You can ask about criminal history on the application. And again, our criminal history inquiry webinar is coming up, but that's always my recommendation is if you can legally ask, get it as early in the process as you can so that you can fairly evaluate this applicant against all the others. Now, the argument from the ban the box proponents is that employers can't be trusted to have this information before the hiring decision, before they've already chosen their best candidate, that we will automatically eliminate people just because they've, got some criminal history. Well, that's just not true. We don't do that. What we do is look at all the green factors and all that, especially if you're following all the policies I suggested earlier, and you're going to be fair and evaluate this person fairly. But, the argument out there is as soon as you see somebody who's checked that box, which I see, so I don't even see applications with check boxes without a place to detail your history and where you really understand what it is, but they call it ban the box because and makes it really sound like employers are using a really simplified process, which I just don't see. But they're arguing that if that box is checked, you're just throwing their application in the trash. Not my history, not what I see people doing. So, but in most places you can do it up with the application, and that's what my recommendation is. Or as soon, whatever the law is where you're at, as soon as you legally can, I recommend that you do that and you gather that information. Because what you don't want is to get all the way through the process and then ask about criminal history and find out, well, this person's medium or high risk. Let's go back and look at the rest of our pool just to make sure we don't have somebody who just presents a lower risk profile, but maybe that person's already accepted another job, right? When unemployment's like it is right now, you may end up in a position where you've lost your second candidate and you're not comfortable with your first. And so I think, okay, so yeah, I do want you, yes, I always recommend that employers ask the criminal history question apart from the background check. I'll say that one more time. The background check, because some of your applicants are liars. I mean, if all the applicants are honest, you wouldn't need background checks, right? So the background check is just a lie detector test. So asking the criminal history question, having a good employment application process where you ask about their reasons for termination and all of that stuff from previous jobs, where you get the details about their education. That's why you have all that process. And then the background check should just be a verification that they told you the truth. Are there any other questions out there? If not, then I think we'll end the webinar. My email address is on all kinds of stuff, and so you'll have that, and you'll get emails from us. So if you have specific questions you want to ask, feel free to give me an email or give me a call even. I would much rather talk to you than do the work that's sitting on my desk to be done today. So feel free to give me a buzz if you have any questions specific to your organization. And, you know, quite honestly, most of us have somebody in our lives touched by the criminal justice system. So if there's a way I can help that person, you know, if either by talking to you or, you know, invite them to call me. I probably have at least one of those conversations a week with somebody who's got some criminal history and they're trying to figure out how to successfully navigate the employment environment with that history. And sometimes I can help. I've got a presentation I do for former offenders on how to find meaningful work. I think it's really important work to do. And so if I can help them, don't hesitate to send them my way as well. Thanks, and I hope to see you on our next webinar. If there's anything I can do, I should do a pitch in. We've talked about background checks, but most employers don't love their background screening company. So if you're one of those, you're probably not an imperative client. And I'm an HR guy who started this company 20 years ago to take care of clients who wanted to get it right and had an expectation of service. We should not ever be the least expensive option. If we are, I've screwed up something. But I can promise you that as far as service, quality, and responsiveness, and the confidence in your hiring decision, nobody can beat us. And that's who we want to serve, as the employers who want that. So if that's you, and there's a way we can help you, we'd love to explore that with you. So please give me a call or shoot me an email on that as well. And as for the rest, thanks. Have a great rest of your week. We'll talk to you soon. Bye-bye.